Hi, good afternoon, ladies and gentlemen, and welcome to the third in our series for this month, Cybersecurity Awareness Month. Today, we want to tackle the novel and emerging topic in Jamaica, not so much in the rest of the world, of data protection and how that impacts the corporate bodies locally. We have two speakers with us today who have a wealth of knowledge between them, and we are sure that their sharing of this knowledge with us today will see Jamaica's data protection landscape being better for it. First up, we have Stuart Hylton, who has over 13 years of experience in information technology and security audit, and over 4 years in data protection. He earned a bachelor's in business administration in computer-based information systems from Howard University and has a number of certification in other areas of security audit for information systems. His experience include business analysis, quality assurance, IT audit, security assessment, among others, and his focus has been on helping clients gain reasonable assurance over the efficiency and effectiveness of their control environment, while also providing value-added solutions that enable their processes to mature. He currently works at Symptai Consulting Limited as the Director of Assurance and Compliance Services, where he leads a team of experts in a wide range of technical audits, assurance, and compliance assessment, following best practices and frameworks, standards, and regulations. This includes, but is not limited to, NIST, ISO, COBIT, SWIFT, as well as PCI DSS. Prior to rejoining Symptai Consulting in April of 2024, Mr. Hylton worked at Grace Kennedy Limited, Ernst & Young, as well as the Eastern Caribbean Central Bank, to name a few. He is a member of the Jamaica Customs Agency Audit Committee and the International Association for Privacy Professionals, KnowledgeNet Jamaica chapter. With him today will be Ms. Najuequa Barnes, who is a certified information privacy professional, corporate consultant, development professional, and adjunct lecturer. Her professional experience spans the public and private sectors, managing high-level research, providing advisory consultation on varying data privacy, corporate and international developmental issues for companies both locally and internationally. She has a hands-on approach and has guided public and private sector entities in crafting customized data privacy strategies aligned with Jamaica's Data Protection Act of 2020. Drawing from her expertise cultivated at PricewaterhouseCoopers, where she spearheaded research and training initiatives on GDPR compliance, she now focuses on raising awareness and sensitizing companies to embrace a culture of data privacy. She holds a Bachelor of Science from the University of the West Indies, Mona, in International Relations, with a minor in Social Policy and Administration. She has a law degree with honors from the University of the West Indies, Cayville campus in Barbados, a Master of Science at the University of Manchester in the UK in International Development, Development Management, and is a Certified Information Privacy Manager from the International Association of Privacy Professionals. Najuequa is a Chevening Scholar, where she received the Governor General's Achievement Award for Excellence in Academics and Community Service. She was inducted as an I Believe Initiative Ambassador by the Governor General and is a director of UNESCO clubs in Jamaica. She recently conceptualized Jamaica's first adolescent mental health conference, coined Mindfulness Jamaica Initiative, as the project lead, supported by the UK's Foreign Commonwealth and Development Office at the British High Commission, with support from members of Jamaica's Chevening alumni community. Ladies and gentlemen, we welcome these two well-endowed speakers, and I urge you to listen carefully and participate in the discourse that will follow. Mr. Hylton, over to you.
Good afternoon, everyone. Allow me 1 second to share my screen. All right. You should be seeing my screen now. I don't know if anyone can give me a reaction just to say thumbs up. Yes, you're seeing my screen at the moment. Okay, I'm seeing the thumbs up. All right, great. Good afternoon, everyone. Thank you for the introduction and thank you for having me here as a part of this discussion around data privacy and protection in the private sector landscape, and how is it that we can use data protection, the Data Protection Act, to help protect our business. So I'm going to be talking about a few things today, and I'll be very quick. I'll surpass the introduction there just because there was a quick overview. I'm going to be covering DPA compliance and focus. One, I'll talk about the standards at a high level. So what are the data protection standards that are outlined in the Data Protection Act? What is it that businesses have to comply with at a minimum? I want to focus a bit more on the 7th standard because we do get a lot of questions on what are the things that we need to be doing around technical and organizational measures. And then I'll take a little bit of time focusing on dark web monitoring, because this is an area that we sometimes neglect from a technical perspective, what information is out there and how that information is actually being used to cause data breaches, or at least to create incidents in our organization. If time allows, I'll touch quickly on privacy impact assessments as a way to help assess your business and determine what are the areas that you need to focus on. But if not, I may just stop at the DPA compliance portion on the dark web monitoring. I tasked myself with trying to capture the entirety of the act, or at least all of the different parts of what data controllers need to comply with on one screen. And I'm sure you all are having a wonderful time trying to read through all of this. So don't worry, we're not going to focus on it at this level. As I mentioned, I'm going to focus on what are the requirements of data controllers for the regards to the data processing standards. And there are 8 standards there. So you don't have to try to read through all of this or have us have a full discussion, because at this point in time, given that we are coming to what is the end of the first registration period, that persons had to register their business as data controllers, I'm going to assume that most persons are aware of what some of the key terms are: data controllers, data subjects, data processing standards. But I'm going to start talking about some practical things that we should be doing today to make sure that our business is secure. Because while the Data Protection Act is something we have to comply with, we do want to take advantage of what are the good practices that it's enforcing in our business to protect our business from what may be some adversarial attacks. So I'm drilling down now, going into what are the data protection standards. And I mentioned that there are 8 standards for processing. These are core to what we have to be doing on a regular basis in order to comply with the law. There are some other areas that we have to make sure that we cover, such as making sure to maintain our data subject rights, being registered as a data controller, that's part of the law, submitting a data protection impact assessment annually, and the list goes on. There are some other things. But what are the things that we should be doing in our business on a regular basis? We have to ensure that we are using data and we're collecting it in a fair and lawful manner, meaning that, is it fair to the individual? Is it expected that we're going to be using the data in this way? Is it lawful? Have we identified what is number 2, our lawful purpose? And there are 6 main lawful purposes, 7 based on if you're also including if it is publicly published information that we have to adhere to. And I won't spend too much time defining those areas, because I do want to talk about what we need to be doing in the dark web. And I'm hoping that persons will be enlightened by some of those areas, because The dark web is real. It's not this fictitious space, and there's a lot of information that's being used there to help create attacks. And why I'm going to speak about what are the requirements under Section 7 or Standard 7, which is protection against unlawful processing. We have to make sure that we are being adequate and relevant, not excessive. Gone are the days where you may go to a company and you're being asked to fill out a form, and there's information that they're asking you for that you feel uncomfortable sharing, or you're not understanding what the reason is for them asking for that information. So data controllers now have to assess and determine whether the information that they're using or collecting in every process is aligned with what it needs to be. So you're not collecting more than you need, and it's not information that the customer, the employee is uncomfortable giving based on what you're explaining. So it's adequate and relevant to what you need it to do, nothing more. Accurate and up to date. So we do have a requirement that we are trying to maintain the data as accurate as possible, and we have a process for our data subjects to keep that information up to date and accurate as best as possible. Retention and disposal, which is Standard 5, speaks to ensuring as best as possible that we are only retaining the data that we need to retain based on our lawful basis for retaining it, and that we are disposing it in a secure manner. So once we no longer need the information, we've processed it for the period that we need, we don't have to use it anymore, we have a secure mechanism for deleting it or disposing of it. And there are some other techniques that I won't get into those details right now, such as pseudonymization that you could use to anonymize the data rather than deleting it, because the objective is that we're making sure it is unusable data after we have no longer needed it, or it's unidentifiable data rather. But core to the act is saying that we should have a way to dispose information once it's no longer needed in a secure manner. We have to process information in line with the rights of data subjects, meaning that we allow them to act on their rights, and there's 6 data subject rights, such as the right to access. Do we have a mechanism in place that allows persons to get the information they need or the information about them when they ask, and we are able to respond to them and provide them that information where necessary within 30 days of them making that request. 7, which is the standard I'm going to hone in on a bit more, of course, speaks to protection against unlawful processing. So there should be a mechanism to prevent a data breach from happening. And I'll talk about, of course, breaches do happen, and you will see that. But the point is, have we tried our best? Have we done what is reasonably expected based on the price and the risk to the individuals, that we have tried our best to prevent a breach from happening? And if it does happen, we have a way to respond to it within a timely manner. And that timely manner, of course, is within 72 hours of us identifying that the breach has occurred. And there, of course, should be no transfers of personal data outside of Jamaica unless we have identified that that transfer is to a secure country, that place has good data protection laws in place. It's not a case that they're saying the government should be able to access any information that is sitting within their jurisdiction. If a server is in China and we are sending data to that server in China, it's not that the government has a right to take that information and use it as they see fit. It's that that information is treated with the same privacy and protection that our laws are enforcing on the data. But as I mentioned, I won't spend too much time on all of those things. I do want to talk about the Standard 7, which is protection against unlawful processing. I speak about this one because breaches are very common. And we, of course, have to ensure as best as possible that we are preventing that from happening. It doesn't mean that we have to create Fort Knox around every bit of data that we have. It is saying that we have identified and we understand the risk associated with that data, and that we are providing a reasonable set of measures to prevent it from happening. So if all you have are paper files, that's how you've been doing business, it is typically demographic information or contact information about your customers, as well as your employees. Ensure that you're locking them in a secure space, and we're limiting who can access that information. So not everybody in the company should be able to retrieve a customer file or retrieve your employee information at will. It's not saying that we have to digitize all our records. that we have to put it into a secure cloud location. It's really saying, have you understood what data you have? What are the risks associated? And you're putting in a consummate amount of control to prevent a breach from happening. And once we've done that, if a breach does occur, we can at least explain what we've done to prevent it from happening and what we're doing to remediate the situation. So of course, that includes our vendors. So if we have third parties that are doing processing on our behalf, the law actually says that we must have a contract in place with that third party, and we have done our due diligence in selecting that vendor. So we shouldn't just say, well, you know, this is a popular name, we're going to go with them and we're going to use them for processing. No, have we verified whether they are a secure vendor, that they're going to do things in accordance with our data protection laws, and that they can respond and help us with meeting the act as best as possible. The responsibility is still on us as the data controller to determine who we give information to and whether they are complying with the law. If a breach does happen and we haven't followed those, if a breach does happen as a result of the processing done by a third party, and we haven't followed those requirements, we don't have an active contract in place, we haven't included data processing agreement standards within that agreement to say, this is how you're going to use the data, you're only allowed to share it with another sub-processor. If we give you permission, you are going to notify us immediately if a breach happens. As some example clauses, if we do not have that in place, then it becomes a question of whether we have put in the right level of control to manage our third party to prevent a breach from happening. We also have to ensure as best as possible that our employees are aware of what the data protection standards are and what risk they pose to the safety of the information. What I'm going to talk about with regards to the dark web monitoring as an example is that on the dark web today, I guarantee you a lot of businesses, if not most businesses in Jamaica, probably do not realize that there are email addresses belonging to your business that sit on the dark web, because while it may not have been retrieved from your domain, as in your URL or your systems that you have control over, persons may use corporate emails to sign up for other things. I, for example, I may use my work email to go onto Travelocity or Expedia if I need to make a business trip. And if that is breached and that information is leaked from there, they now have my corporate email. And in some instances, they may have my password that I used to sign up for that service. And that gets dumped onto dark web. But we know how end users can be, because we have so many passwords to manage. We've now used the same password that we log into our network on another site. So the same password that exists in multiple places. So if it gets breached in one place, it is usable in another. So that's why I talk about ensuring that employees are adequately trained, because we need to make them aware. If we have as a corporate policy that you should not use your company email to sign up for services outside of the organization, then that is something we have to remind them about so that they're not doing it. Unless there are certain examples of when they can. They might be signing up for a learning platform, Udemy. It might be a part of our agreement and organization that we use Udemy, and persons may sign up with their company email to use that service. So as I mentioned the dark web, and I'll talk about that just for a brief time. It is a real place. It is not some fictitious, ambiguous space. It is a part of the internet, which is suspectedly even bigger, because the deep web and the dark web, deep web is part of the dark web, or the dark web is part of the deep web. It's a real place that people do go for malicious activities. Some of it may not be malicious, but a lot of it may be because it's hidden from the regular internet that you and I use day to day. To access it, of course, you use different tools than our regular web browser, such as Chrome or Firefox. We're not using this. We're using another browser called Tor, T-O-R. And going into that space is not recommended that persons just download Tor and go into the space, because there is malicious activity happening at times. You connecting to the dark web may be an opportunity. If you're not aware of what the risks are, there may be an opportunity for somebody to connect to your machine, and that becomes an attack. So I'm only giving this as informational. I'm not encouraging persons to navigate to Tor, download, and start using it or trying to use it in an uneducated fashion because you may be exposing yourself to potential breaches. But I talk about the dark web because that's where the information is real. You know, dark information that gets breached from companies, from individuals, at times gets dumped into the dark web, and it may look something. I'll show you an example of what it may look like. Breaches, as I mentioned, are very real. They've been happening. Here are some examples of companies that have, you know, this is public information, companies that have experienced a data breach that become publicly aware, that we're publicly aware of. I show these examples because these may be familiar names to you. It happens. It's not that they haven't done enough to prevent it from happening. It's just that threat actors on the internet are actively trying to engage and trying to get into these spaces. They have different motivations. Some of it may just be persons who are trying to see whether they can get in or not. Some persons may actually be trying to get into the space to use the information maliciously. Getting things like usernames, like emails and passwords, as simple as they may sound, may lead to a bigger breach. It may be an opportunity for somebody who can find a public URL about your organization that does connect to the internet to connect and breach the information there. And breaching the information by taking it out of your environment, whether they dump it onto the dark web, whether they share it with another organization or sell it, whatever it may be, that becomes a reportable data breach that we now have a responsibility to report to the individuals affected, as well as to the information commissioner within 72 hours of us identifying that breach. Not from the moment the breach happens, because the breach may happen and we really aren't aware, but from the moment we do become aware, the clock starts ticking. Here's a very recent one. This is the Revenue Authority in Barbados. It's been big in the news. I think the last 2 weeks is when it happened. What I'm showing you here is an email or conversation in the dark web of a hacking group who has taken credit for this breach, sharing the files. So what you've seen redacted there in the red is the name of the files, because we're not encouraging people to try to go find these things. It's just, this is real. And what they're saying is that they were able to pull over 60,000, approximately 70,000 rows worth of individual data associated with their driving records or, you know, driver-related information. So names, email addresses, phone numbers, passport information, driver's license, and all the way to the end of the message, you will see the little smiley face saying, and yeah, tourists are there too, because they're bragging to say, listen, we actually hacked the information from a government service in Barbados, and this includes not just citizens of Barbados, but it may include foreigners too who have used these services. So it was a public-facing service. It was the revenue authorities, essentially equivalent of our tax administration portal for persons to log in, pay for their driver's license, submit their documentation. Approximately 70,000 people were affected. It was pretty embarrassing for the government, as they're still trying to figure out the extent and what happened. But I speak about the dark web because information like this will get dumped there. But what we've identified recently, you know, just navigating that space through our cybersecurity team, is you have this plethora of email addresses, passwords that have been exposed from the government. So you'll say at barbados.gov. That is information that could have been used, because there is a theory. This is all theorized. It hasn't been confirmed, but there is a potential that the Revenue Authority website may have been hacked using an administrator credential. So it could be that they pulled the information from the dark web and then used it to then cause a further breach. All theoretical, because all this hasn't been confirmed, but that's what can happen. If your information is there, as you've used it from some other site, it doesn't have to be at work. It can be pulled from that space and then used to formulate a bigger attack. And I'm saying all this to say that companies have to take a proactive approach to identifying where this information has been made available on the dark web, because we don't have a mechanism to necessarily clean it from there. But we have to make end users, day-to-day employees, aware that your information has been put out there through when you signed up for a Macy's gift card or whatever it may be. And now we have to make sure that you're actively changing your password wherever this information may have been used. And that's why we need this constant awareness to consider, no matter how much we try to prepare end users for what may happen, they may do things like that, and they may use information incorrectly. Here's another example, of course, of information just being dumped onto the dark web. And this information from a massive breach could be used to cause a further attack later on. And as you've seen, some of the information has been blurred out because it's not necessary for the demonstration. But of course, what we want to do is prevent these things from happening in the future. So I did mention, of course, I want to make sure I'm on time to allow the other presenter time. I, of course, will take questions afterwards, but what we want to ensure is that there's a mechanism in organizations to identify things like that, because it's another space that can lead to data breaches, which under the Act becomes a reportable matter. And if we're not showing that we've taken adequate steps to prevent it from happening, that's what may lead to a fine. It may lead to us having to pay for damages as well to the individuals because we were not adequately trying to prevent things from happening. Hand back over to the host.
Thank you very much, Mr. Hylton. And we note the emphasis on Standard 7, as well as the insight that you've provided with respect to dark web data dumps and how these can be leveraged by malicious actors. We now hand it over to Ms. Barnes and ask that you keep the questions until the end of her presentation, unless it's really, really burning, and we will take all the questions at that point. Ms. Barnes, if you're speaking,
are
we're
you
not
seeing my
hearing you.
screen?
Yes, so we're hearing you now and we're seeing your screen, but it is in the edit mode, not the presentation mode.
Let me just stop share. Hold a second for me. Let me just reshare. Let me put it in presentation. Okay, so everyone is seeing my screen and hearing me clearly?
Yes, ma'am, we are.
Okay, great. So Stuart, thank you for that, presentation. And Stuart did an excellent job in going over some core points. So the points that he went over in the interest of time, I won't, elaborate on those points. So the picture that we have here, I just want to bring our attention to it for just a second, just a brief moment. And when we're thinking about the private sector and the Data Protection Act, we're thinking about dynamic businesses across industries, across sectors. And the private sector's core objective is really to contribute to the development of Jamaica. We're thinking about Jamaica within the context of the Jamaica Data Protection Act. And we're thinking about healthcare, finance, the manufacturing industry. We're thinking about the beauty industry, education industry, wide cross-section of companies. And if we look at the screen here, surrounding all of those different organizations that comprises the private sector, at the core of that should be data privacy. So if we're thinking about the Data Protection Act and the private sector, we need to understand that a core part of those operational existence of private sector organizations across a wide cross-section of industries should be the Jamaica Data Protection Act. Hence, this diagram in trying to illustrate how data privacy should be the core of that consideration. So I had a very ambitious roadmap, but in the interest of time, I know we won't be able to go through everything, and Stuart helped me with my presentation in going over some of the core points. So we want to highlight the importance of data privacy of our businesses in today's environment. And we want to provide an overview of key data privacy regulations and compliance obligations for the private sector. We want to demonstrate the business benefits of strong data privacy practices, including competitive advantage and risk reduction. We want to discuss the challenges private sector companies face in implementing data privacy framework. And we also want to offer some, recommendations as to how organizations can actually implement a data privacy framework in their organization. So when we're thinking about the Jamaica Data Protection Act, the key objective is really to safeguard personal data. So think about us, each of us here being a data subject, right? So even though we're talking about the private sector from the perspective of being a data controller, collecting the personal and person-sensitive data of data subjects, we want to have an appreciation that each of us here on this particular webinar is a data subject. We own our personal data, and the Act is empowering us as data subject to determine how is it that our data is being collected. It is giving us a sense of autonomy and being a critical part of the decision-making process. So think about you owning your house, your car, that's your personal property. And similarly, data privacy is an innate human right. So this act was created stemming from the GDPR, which, would have been that global yardstick, which other Commonwealth countries would have created their data privacy laws and regulations, that us as Jamaicans within our international relations, within our engagement with the world, we too would have had to institute a data privacy framework to communicate to the world that we're open for business, that we can safeguard the information that they're collecting. So Stuart would have referred Standard 7 about international data transfers. And this trickles down to us as data subjects and within the macro level as businesses. So when we're engaging with organizations, we need to be asking ourselves, can I trust this company with my information? Do I feel safe in sharing that my personal data with that or particular organization, especially as Stuart, would have alluded to, from a data controller sharing information with a data processor? And under our Jamaican Data Protection Act, the accountability would have been placed on the data controller, unlike that of the GDPR. So the act is really there to uphold the rights of individuals, giving them autonomy and control over their data and establishing that guidelines, national guidelines about how data should be processed. Now, many people are like, I just have a little small business, I have a doctor office, but the act, the scope of the act, it applies to all data controllers. So whether you are an established organization, you're an individual and you're processing data, the act is not specific to a particular industry. Once it is that you're identified as processing personal data as a part of your business processes within the public or private sector, the legislation applies to you. Now, we want to just quickly between understanding the distinction between data privacy and data protection. Now, as I mentioned earlier, data privacy is acknowledging the rights of individuals, us as data subject, each of us having personal control over how our data is collected. And the principles here, it is really referring to transparency, consent, and having that level of control. Now, the data are concerned, right, with the standard 7 as to the organization and technical measures that private sector organizations would have implemented to create compliance with the data privacy concept. The data protection is really what measures you put in place to ensure a data privacy secure environment. Now, when we're thinking about personal and sensitive data, again, Stuart would have, alluded to this, so I won't go in this in much detail, but I just want to add to his point that if it is that you, within the private sector, that you're processing sensitive personal data, you need to ensure that you have heightened level of data privacy handling processes to be protecting that data. Now, what are some of the legal grounds for processing data? Consent. Right? And consent here, I want to use it very cautiously because consent can become a very technical terminology. And we don't want to base our business processes on consent because it is something that can easily be withdrawn. We want to ensure that the data subject is given explicit permission for the processing of his or her data. And that should be informed consent. So the data subject actually knows what he or she is actually agreeing to. And there should be established principles that this consent can be withdrawn. But as I said before, we want to be very careful about how we use that terminology, especially within the context of business operations and data privacy. Contractual necessity. Is the data subject a part of a contract for which their personal data is going to be processed? For example, if it is that you need to fulfill a particular customer order, you need to process the person's personal data as a part of that contractual obligation. Legal obligation, we're thinking about legal obligation. We are looking at, for example, processing, fulfilling requirements for tax and employment laws. Is there a legal obligation that has to be fulfilled that is set in the law for the data to be processed? And the most popular purpose in that regard would be for employment and tax purposes. We also want to think about vital interest, and vital interest alludes to, for example, mostly exercised within emergency or medical purposes where somebody's life is at risk or safety is at risk, and the data needs to be processed as a matter of urgency. We also can think about public interest, where, for example, an official public organization has to process data in the national interest of the public, such as, for research, justice, or security interests for the nation. A legitimate interest is somewhat of a flexible legal ground where we're thinking about the interest of the data controller, but it should not override that of the data subject, where, for example, you are gonna, for example, where you have matters of fraud. Now, Stuart would have done an excellent job in going through each of these standards, so I'm not going to go back through these again, but I just want to add that these are, in my opinion, the yardstick by which organizations have to make an assessment and evaluation to the extent to which they're compliant, understanding where your company is, in relation to each standard and what you need to do to get you to compliance within each standard. Now, he also spoke about the data subjects' rights. And in my opinion, this is one of the most crucial, standard, because if we think about the provisions in the Jamaica Data Protection Act, it was really established to protect the secure processing of the data subjects. So it's really putting the responsibility, the onerous on data controllers to ensure that secure systems, that secure data protection measures, as we alluded to earlier, are in place to ensure the privacy of the data subjects. So we talk about, the right to be informed about the collection and use of the data, right to access, right to collect accurate data, right to processing and portability. But of course, each of these rights have to be informed by legislation. So, for example, a data subject just can't say, I want my information to be deleted. Everything has to be governed by legislation. So it's not an absolute right, but it's a right nonetheless, and it has to be examined on its own merits. Now, why is data privacy important for the private sector? Because many persons, the question that many companies, that we work with, they're like, what is the incentive of, complying with the legislation? Government just want to give us more problems, want us to spend more money. But when we have a different perspective and we understand that data privacy is not a burden, but it actually, if integrated and adopted in our operations in the private sector, that it actually adds to business efficiency. So we want to have a different perspective, as opposed to, Lord, this is just another problem, not a budget line item. But if we think about it being a part of the solution as opposed to the problem, then we'll have a more sense of urgency in adopting a data privacy culture within our organizations. So, for example, we can look at this quickly. We want to build trust among our customers. So you would have worked for many years in establishing goodwill within your organization, and customers are going to feel more safe and are going to feel safer and secure in engaging with organizations within the private sector that respects data privacy laws, and that are actually taking steps in implementing measures and systems within their organization to be protecting the data that they're sharing with these data controllers. So if you think about the trust and you think about the goodwill that you've established, then you will understand that this is actually a benefit. When you're thinking about competitive advantage, this is actually a big one, especially within the private sector, because most private sector organizations are established to provide a service. You actually also want to be generating revenue in your organization. So if you have other persons within that same sector, that same industry, customers, stakeholders, even international investors are going to be more drawn to organizations that have data privacy systems and policies in place, therefore giving you a competitive advantage in your industry or within your organization. And that also is coupled with customer retention and acquisition. You can get new customers, new clients, engage new investors and stakeholders because you're going to be an attractive organization who is respecting data privacy laws. Now, when we think about regulatory compliance, we know that that is at the helm, right, that is driving data privacy. But we don't want to just think about, oh my God, if I don't comply, I'm going to get fines and my business is going to shut down. If we think about it from an improved operational efficiency in our business and building a culture of data privacy, then regulatory compliance becomes natural. So let us not approach data privacy from the perspective of, I need to do this, and if I don't do this, then the fines will come. Yes, we need to acknowledge and be mindful of the fines, and we need to secure our organization. But if we approach it and have a perspective about building business efficiency and a culture and a change management system, then the compliance will be a natural result of that approach. You also want to mitigate risks and avoid financial losses, right? So we're not planning for something to happen, but once it is that you're processing any type of personal data, there is a potential of risks, and you want to put the systems in place to mitigate against those risks. So how can data privacy compliance, help and motivate business efficiency? And I think this is important because, as I said, many conversations that we have with organizations, the big question is, what is the incentive for compliance? And that is a recurring question that so many people ask. How is it going to benefit my organization other than, us preventing legal implications and fines? How is it going to have a direct impact? And if you're thinking again about the private sector, you're thinking about revenue generation, you're thinking about providing goods or services within whatever particular industry, and you want to know that whatever systems you're adopting, it is actually going to be boosting your operations of your organization. So we talk about reduced risk earlier and you're minimizing data breaches. And also streamlining data management, because when it is that you have a structured data privacy framework in your organization, you have better control over the secure processing of data. We also want to look at a big one, is minimizing business disruption. And that is so important because when it is that you do not have any type of data policy systems or framework in place, including what Stuart would have alluded to earlier, you are leaving your organization exposed to data breaches and, by extension, disruption in your organization's operations. And that is going to lead to fines. It's a rippling effect, losing customers, reputational damage, and you're losing millions of dollars. So when you weigh the cost of non-compliance, it outweighs the cost of actually complying. And as private sector organizations, you have a wealth of digital assets to protect. And these digital assets cannot be protected without you having a structured data privacy framework in place. Now, we may be thinking about it from the theoretical point of view, but Stuart would have made, a very significant contribution earlier when he spoke about exposure on the dark web. And this exposure is based on the sophistication, right, of cybersecurity breaches. So if it is that you want to be protecting your digital assets, we're thinking about financial data, employee data, intellectual property rights, your contracts and agreements, your digital marketing assets, your email communication, your health records if you're in the health industry, and the list goes on. This cannot be protected on its own without having a structured data privacy framework in place. Now, we spoke about the benefits earlier, about the competitive advantage, the operational efficiency, and reduced risks. Now, while we know that the law has these provisions, we don't want to ignore the challenges that private sector organizations may encounter, particularly SMEs. Who the biggest complaint for SMEs, we don't have no money, we don't have no money. We want to comply, but the cost of compliance is beyond what we can afford. And this is a recurring challenge for many SMEs. And remember that the Jamaica Data Protection Act is fairly new in terms of its institution, and as such, many organizations wouldn't have had the budget. So this is something now that companies will need to be planning for and ensure that is something that they're budgeting for, and to manage the cost of non-compliance versus compliance. Now, we know that interpreting and applying legislation can be very complicated. Hence, the reason why you have companies like Symptai, UCI, and a wealth of other organizations, and also the OIC that is there to provide support for companies, for private sector organizations, and public sector organizations too, that want to become compliant. And a core part of compliance is understanding the legislation. And Stuart would have explained each standard, and there are also other complex standards in legislation where you will need expertise to explain these provisions to help you to become compliant. And he also would have alluded to data sharing and third parties. And this is so important because unlike the GDPR, in our Jamaica Data Protection Act, the data controller is absorbing, right, that the legal implications of breaches, because the data subject is sharing that information with you. And even though you would have established a third-party agreement with a vendor, the onus is on the data controller to ensure that you're instituting systems in place, that the data processor is acting on your instructions, and that you have your agreements in place to be protecting the information shared by the data subject to you, and by extension, you would have shared it to the third parties. So you need to ensure as private sector organizations that you're having these third-party agreements in place, that you're acting on your instructions, and most importantly, you're doing your due diligence to assess who you're actually doing business with. So what are the steps for implementing a data privacy framework? So we hear about the provisions, we hear about what we need to do, we hear about the legal fines and penalties. How can we move forward in a practical way to ensure that we are becoming compliant? And this is really put in a very simplistic way, but I just want you to understand it. So first of all, before you can go forward, you need to understand, where are we now? What are the current practices and data processes? What are the data classifications in our organization? What are the risks? How are we processing data now? And where do we need to go in compliance with the Data Protection Act and also other supporting organizations that inform how each industry is processing data? So before you can go to the other side of compliance, you need to assess where you are now and where the gaps are, and how can you fix those gaps to get you to the journey towards compliance. Now, a core part of implementing the framework is also developing structured policies. And this is very important because, we have the fanciest policies. We can have we can say we want to be compliant, sorry. But if it is that you don't have policies in place to inform your organization about data processing, then what is going to be that guiding map? Now we're talking about policies for data subjects and operations of secure processing in your data. We're not just talking about your customers. We're not just talking about your stakeholders, but we're talking about employees as well. Because I think, through conversations and consultations, many people miss that your employees are also data subjects, right? So you also have to have policies in place to inform how is it that you're securely processing data internally in your organization on behalf of your staff members, because they're data subjects and they will, and the law actually empowers them to hold your organization accountable for how you're processing data. So we have a slew of policies. You have your data privacy policy, your data subject access request, your data breach response plan, your privacy notice, which is very important because it is your way of communicating to your data subjects about what is it, how much information you're collecting, why you're collecting it, how you're storing it, who you're sharing it with, what kind of protective measures you have in place, what's the data retention, period. All of that is important for you to communicate to the data subjects who own the data about all aspects of processing. Now, Stuart labored this point, and I want to labor it again. Train your staff members. Because even though I labor on the point of policies, the greatest, fanciest policies cannot be implemented without an enabling environment being created, right, by the employees to facilitate implementation. So the employees need to understand, what is this data privacy about? How does it apply to my organization, to my industry, to my particular job function? Why is it important, and what role do I have to play at the organizational level to facilitate compliance? And how can I, as an employee, be held accountable on behalf of the organization? So the training needs to be tailored and specific to the organization, and the staff members need to know that they are the guardians of data privacy, and they are the ones who are going to be creating that enabling environment to facilitate compliance and implementation of a data privacy framework in the organization. Monitor and review, monitor. As Stuart would have referenced earlier, you have to be mindful of what is happening. And as such, even though you train the staff, even though you have the policies, you need to have continuous assessment and monitoring to ensure compliance. And remember that regulations evolve, and as such, you want to ensure that you are keeping on track. Now, I see time is running out on me, so I'm just going to quickly, breeze through this part. But while financial penalties are crucial, and we're thinking about 4% or more of your gross annual revenue, we're thinking about criminal liability, enforcement orders, stop orders, publicity orders, and compensation claims. I think, in my opinion, that one of the most mindful or most important cost for compliance is reputational damage. Now, your company may be rich and you can pay the money, but in my opinion, no company nor no data subject rather is going to want to do business with an organization where there is no trust, where there are constant data breaches, where there's no respect for data privacy of the information shared. So while you may be able to pay the money, in my opinion, I think reputation, personal reputation, and corporate reputation on the part of the data controller is one of the core aspects, the core consideration that no amount of money can repair reputation. So you want to ensure that the goodwill, the organization that you'd have built for so many years, that reputation, that trust is maintained. And I alluded to loss of business opportunities and operational disruption, and this can cause loss of millions of dollars, right? And the cost of breaches as well, and the legal implications. So there are so many costs and there are so many disadvantages that you need to consider outside of the legal penalties, which is equally important to bear in mind as to the cost for non-compliance. So we see the benefits. How is it can build business efficiency, investment within the private sector, trust among your clients, right? Opportunities, competitive advantage. But if it is that we do not have the proper systems and framework in place, there is a massive, huge cost for non-compliance. So if we're thinking about best practices, Stuart would have alluded to the standards here, reflected here about data minimization. Only collect what you need, because the more information that you collect that you're not processing, you're exposing your organization to data breaches. He also spoke about, encryption and anonymization, that you need to put system in place to protect data at rest and in transit to prevent unauthorized access. You need to have clear mechanisms in place, especially if it is that you are processing sensitive personal data. What kind of heightened level of handling processes you have in place to be securely processing this data. You want to also have a data breach response plan in place. We're not planning for the worst to happen, but once it is that you're processing any type of personal data, there is always a risk. It doesn't have to be negligence, but there is just always a risk. And so if a breach happens in your organization as a data controller, what will a response look like? Being proactive, being responsible, being a responsible data controller. What will a response look like? And Stuart would have mentioned the legal obligations in reporting and also informing data subjects as soon as possible, controlling the breach, and you want to ensure that you have the right systems in place at the technical organizational level. It's also important that you register with the OIC. So the OIC has started publishing its first list of data controllers, and it's going to be a phased approach. As they're going through the approval process. More and more companies are going to be published on their data controller register. So more and more data subjects are going to be viewing this register, just as how they look at companies are registered. Is a legal registered company. Can I, trust my organization to do business with them? Companies are going to start, so data subjects and companies are going to start doing their research on OIC data controllers registered to see, is this organization a registered data controller, and can I trust this organization to establish a business partnership with them to do, to ensure that my data is securely processed. So I strongly advise you to go through the process of registration. So that is it for my presentation, and I will open the floor now for questions to myself and Stuart, I guess, based on what we would have shared. Thank you.
Thank you very much, Ms. Barnes. You really pushed the envelope on time, but the information that was imparted is actually quite relevant to the topic and the current situation in Jamaica. So I will open it up to the floor. If there are any questions, please indicate by raising your hand or type it in the chat. If I don't get any takers, then I may have a couple for either or both of the presenters. So I'm not seeing any questions in the chat. So my first question is to both presenters. Why is the cost for professional data protection services so high when you consider the number of potential clients versus the number of suppliers of data protection services and training? Why do we have to pay so much to get the service as opposed to you're recouping your losses or your overheads from the volume of sales that you get?
Stuart, do you want to go first?
Ladies first. I went first in the presentation. I don't mind. I'm going first.
All right, I see you putting me on the spot here, Stuart. All right, no problem. So, that is a very, pressing question, and it is a genuine concern. And when you're thinking about designing a data privacy framework, the cost is not standard for all organizations. So, for example, for government entities that we work with that are large data controllers, the cost will not be the same as it is for a data controller that processes a not such a large volume of data. And also the cost is going to be dependent on the level of risks and the amount of work that needs to be done to implement a data privacy framework for the organization. So the size of the company, the volume of data that is processed, the type of industry, the risks. Sometimes, for example, a real estate organization will have multiple agents to be trained. So the cost is not standard, and it is determined by, several factors, including what I just mentioned. And when you're thinking about data privacy, it's a very intricate process. It's not like going to company's office and registering a business and getting it back tomorrow. It's a phased approach over an extended period of time to move a company from where it is at this present stage to where it needs to be. Now, I do agree with you that when you're thinking about volume, the Chinaman approach, if you want to put it there casually, that the more and more companies you help, especially within the particular, similar industry, the work can become not as complex. But I also want to qualify that by saying that each organization, even though they may be within the same industry, processes data differently. So the policies are not necessarily copied, are not copy and paste. You have to understand the data processing of each organization and tailor and design the policies for that particular organization. And it does take work. And the organization is depending on your expertise and direction and consultation to ensure that they have a very comprehensive data privacy policy in place. Now, I think one of the major considerations, in relation to that question are SMEs. And as such, those companies, you find that not as many of them are complying, even though a wealth of Jamaica's business enterprises are made up 75% are SMEs. So I think as consultants, we will have to think about having, a tailored package and structure to, enhance compliance as opposed to price being a deterrent. So I hope that answers your question.
Yeah, I would ditto the sentiments, of course, is that this is a nuanced space. It is still somewhat novel to Jamaica and the Caribbean as a whole. It's a specialized skill set that is needed in order to not just put the things in place, but assess what is relevant to your space. You're talking about professionals who are skilled in law, cybersecurity or IT security, risk management or understanding and evaluating risk, audit as well. And you will find as persons look for data protection officers to fill that particular role, that this is very hard to find persons with these skill sets. I, however, would challenge the idea that it is expensive, because you will find, especially given the competition in the space to provide these services, that there are packages to fit everybody. We, for example, at Symptai have smaller approaches to small businesses. If you're a single office, home office type setup where you need to process sensitive data, medical information, you do present a particular risk, but the risk is smaller. And we have a much smaller package to support you in meeting what are your day-to-day needs. But at the same time, as was explained by Ms. Barnes, that if you're a large organization, complex processing activities, you're going to have a much higher risk of a potential breach, of the opportunity for there to be persons who misuse data within an organization, and that requires an extensive amount of work. Compliance, and you'll notice for any organization that has a compliance program, it is not a one and done approach. We are working assiduously to put in place measures that not just get you across the line today for registration, but are providing you a continuous mechanism for adhering to what the law requires. And that is not a simple task. So I would say, if there are ever instances that you think that this is too costly for what you're getting, take the time to converse with the person that you're trying to get the services from, to understand where the needs are and negotiate on what you actually need to do. Because there is also the opportunity to assign personnel within your organization to support that, or at least learn what is necessary to get everything going rather than thinking it's a too costly an endeavor, and will take the risk of, I will take on the risk of potentially having reputational damage, fines, and so on if there is a breach, as we've seen in case of the Revenue Authority in Barbados recently. Their minister
Stuart. So we lost Stuart.
which sits under there.
Okay,
Oh.
Stuart, we lost
Sorry.
Stuart, the minister, with respect to the Barbados breach. So if you could just recap what you said between them.
I was saying, hear me now?
Yes, we're hearing you now.
Yes.
Oh, so I was just saying that
Stuart, not hearing you again.
apologies, I just hopped back on. Still have an opportunity to finish my response?
Yes, you can finish the response because you were making a very good point in relation to the Barbados breach. So you can finish the point.
Right. So just for persons to be aware, the Ministry of Innovation, Science and Technology oversees what is the Data Protection Act in Barbados. So they have a law that was passed and mostly enforced as of 2019. So parts of the law are still not enforced, but they have a data commissioner. And here it is that the Revenue Authority, which also falls under that ministry, has not been able to adequately respond to the public about what happened and what they're doing to protect individuals. And you can find the minister's response on YouTube. But the minister has been trying to alleviate concerns. They're trying to address it, but they clearly do not have a proper process in place, because even the ministry should have what they call a data privacy officer in place to address this. They don't. And it's creating what is now reputational concerns for the government, because the next time they come up with a digital initiative that says, put your information in the space, there's going to be a lack of trust. We know we have that here in Jamaica. Every time we talk about certain opportunities to go into the digital space, we have to talk about how we can trust the systems in place. And what we also have to think about that for our businesses. So we're not asking just anyone to support us in this journey. We are asking persons with a very unique skill set to help to input all of the mechanisms we need to reach compliance and to build trust. So I wouldn't take it lightly to say we should not invest in this properly. But I do think there are opportunities to find affordable solution given what the landscape and market is for persons who are providing these services.
I thank you both for those responses. But when I look at the way in which some of the comments are made, particularly from those smaller entities who put forward at the first instance the costs, at the second instance their ability to afford, and at the third whether or not they really need to be doing this sort of thing. How much of a role then do you both think that the regulator has in sort of pushing a little bit more in terms of sensitization of the ecosystem, particularly the SMEs and some of the micro organizations, where they believe that since they're not really a big company, the data protection doesn't apply to them? What would you have to say to them as well as to the OIC in terms of sort of bringing a little bit more synergy into the compliance mechanisms?
Ms. Barnes, you want me to go first this time, or you'd like to take it first?
You can go ahead first.
Right. Not putting you on the spot twice. I do agree. Don't get me wrong. I do agree there are going to appear to be very expensive services, and one thing I would love to see from the commissioner here, as they build out their function, is more guidance and availability of information to allow persons to help themselves. When you look at more mature environments like what's happening in the UK, what's happening in France around data protection, there is a plethora of resources that can be used. So anyone here on this call, if you're interested in, helping your organization with data protection, there are tons of resources that are free. Some templates for data protection policies, templates for performing a privacy impact assessment, and so on that exist. Now, I will say you do need to spend some time. This is not a plug and play. As Ms. Barnes said, you cannot just, plug in a generic privacy policy and say we're good. You do need to do some work, but I do think organizations could do more to help themselves if more of these guidance notes and templates and supporting information was readily available here in Jamaica. I don't take for granted that it is a substantial work to make that available, and the Information Commissioner's Office is working to help build out their own program, their own team. So this is probably going to take some while to happen. But I would encourage them to potentially engage with consultants to supplement the work that needs to be done so they can get it out faster. Over in Bermuda, it's a similar thing. They have what is called their PIPA law, Personal Information Privacy Act, and they have quickly built an office that has quickly pushed out a lot of resources, including their own roadmap to guide companies to build their own privacy program and information within the organization necessary to comply with the law. So there are more companies there that feel like, I can help myself before I try to engage a consultant. Some of the larger organizations are immediately reaching out to consultant expertise because it is a lot of work. But the smaller organizations who feel like, well, I may not have the ability to invest in this right now, I can at least take the high risk areas off of my checklist by using the resources available there. I may just have to spend some extra time doing it. So that's what I would like to see here in our environment, that there is more resources made available through the Information Commissioner's Office so that people get a sense of how official it is and appropriate, that they can help themselves, as well as they can feel more confident when they get a consultant to help them that they are doing the right thing.
I just want to add to that point, Stuart. I think that's an excellent point. And if it is that, we're looking at the UK and more advanced, countries, then, the systems that they have in place, it does provide a rubric for, especially smaller companies to work with. But in Jamaica, I think we have to have an appreciation that our legislation is fairly new. The OIC is still work in progress in putting certain systems in place, and I envision that many of these frameworks, self-help systems will become available to SMEs. I just want to add a crucial point that I think that partnerships are going to be a critical part of compliance, especially for MSMEs. So when I mean by partnership, for example, we're having this webinar. You have the Shipping Association of Jamaica, you have the Private Sector Organization of Jamaica, you have JMA. You have so many associations that, where they can pool resources together to find compliance solutions for their members. And I think the Medical Association of Jamaica, I think that they took that approach in addition, to other organizations, and they find economical solutions for especially their smaller their members who are processing, less data as opposed to, their large data processors. So I think the partnership through associations will, provide an economic route for organizations. And also, I think as time progresses, those systems will be, become more readily available. And the other thing is sensitization and education. So the OIC is still building, is still growing. And I think us as consultants, Stuart and I would have made the time to be here, and many other consultants, who would have done sensitization sessions. These are very, very important in educating SMEs. Now, the larger organizations, especially within the financial and medical sector, they would have an appreciation, as to why they need to budget for that, and they would be able to more afford, those consultations and to embrace and implement those systems. But I think that for, SMEs, I think that these type of webinars, these type of sessions, outside of the OIC are crucial support systems that provide a medium for education and understanding and providing a platform for responding to questions. But I'm understanding that, listen, once it is that we are a data controller, notwithstanding the size of the organization, you want to grow at some point in time. It is a journey towards compliance. And if it is that we want to build and we want to grow as smaller entities, then this is a part of the journey. So I think these platforms are crucial, and partnerships through member associations also will play economic solutions for compliance until those systems and frameworks are built out in Jamaica, like what we have in other territories.
So thank you both for that. Time really doesn't allow us to get much deeper into the discussion, but I really want to thank both Mr. Hylton and Ms. Barnes for coming here and putting a lot of food for thought on our plates. The legislation is young, not fully in effect. The Office of the Information Commissioner is getting there very slowly, but they're making progress, and the ecosystem itself is taking shape. The message I am getting from the responses is that, businesses really need to consider the cost of non-compliance and what really the challenge is. I am seeing a hand. Okay, I'm not seeing who the hand. Oh, Mads. Let me unmute you so you can.
Can I?
Go
Good
ahead with your
afternoon.
question, man.
Yes, I put in the chat. Can you show back the slide with the fines? It went a little quickly for me.
Okay.
Please, thank you.
All right.
All right. So while we try to get that going, I really have to drop off the call, and so I will hand over to one of my co-hosts. But I want to thank you both and the audience as well for remaining largely here and listening to the discourse. We've started a conversation, and we're by no means where we ought to be with it. And I hope that as a sector, we can continue the discourse. Thank you all for coming, and we'll see you at our next event.
Okay, this is the slide with the fines.
Thank you. And the presentation was really great. Thank you very much.
Thank you. You're most welcome.
All right, if there is no more questions, thank you again for attending our webinar. And we'll see you again tomorrow for our fourth event. And we look forward to seeing you tomorrow.